Washington, as a legislator, I mean, what do we do about that? Especially because, look, as conservatives, we don't necessarily want lots of new laws. We don't want alphabet soup agencies out there with whole new controls. So how do you balance that? What do you go about doing about this?
Well, you know, I think one of the things we should think about is the sweetheart deal that big tech has gotten from government. I mean, big tech hasn't gotten so big and so powerful just on its own. It's gotten a whole bunch of sweetheart deals from government, none more so than Section 230 of the Communications Decency Act, which says that big tech is not subject to the same rules as other media companies and media providers, including, for instance, the platform you work for, Kim. I mean, you're subject to correct, yeah, publishers. You're subject to a different set of rules than big tech is. And big tech has used that in order to, in many instances, discriminate against conservatives and libertarians, but yet avoid the consequences of it. So I think we need to look at this cozy relationship between big tech and big government, because that's gotten us a lot of the way, or far along the way where we are now.
So just push back on that a little bit. Just ask, no, I mean, I think that's a very legitimate question. But then there are libertarians, some conservatives out there who say, in fact, if you go and you take away and change CDA 230, that what you're in fact doing is you're going to give those people, if you impose liability on them for anything that anybody says there, and they suddenly, now they are liable for that, it's just going to cause them to crack down even more. That they're going to go after even more conservative voices, and they'll say, look, we're under law now liable for anything that comes out on our websites, and so we're just following the law. Yeah, protecting ourselves.
Here's the thing I would say. I think it's time that we told these tech companies, if you're going to get these kind of deals, you can't engage in what we in the law, and I'm a lawyer by trade. My background is in the practice of constitutional law. And in the law, we have a familiar phrase for this. It's called viewpoint discrimination. So we ought to tell them, you cannot engage in viewpoint discrimination. You cannot go discriminate against conservatives because they're conservatives. You can't go discriminate against libertarians because they're libertarians. You want to stop people from committing crimes on your platforms? That's great. You want to stop people from advocating violence on their platforms? That's great. That's not constitutionally protected speech anyway. But if you want to edit constitutionally protected speech, if you want to target conservatives and libertarians, you're going to be on the hook for that.
So what do? You get rid of CDA 230, you change it, what do you do?
Yeah, you can change it. I think we should have a look at all ought to be on the table. I think we should consider amending Section 230 to prohibit this kind of discrimination, this viewpoint discrimination. The goal here, Kim, is not to get less speech. The goal is to get more speech. The goal is to end the sweetheart relationship between government and tech, not to get government more involved. Because government has given tech this special status, that's why we are where we are. And we should talk about privacy, too.
So that's the culture. Now we know how we get what we get. You heard the senator. Do you agree with some of his approach? How do we fix it? What do we need to do? Do you do something about the Communications Decency Act? Do you do privacy legislation? What would it look like in your world?
Well, all of the above, but to drill down on Section 230 of the Communications Decency Act, there's been a proposal by Senator Cruz that you can still have 230 immunity, but it has to be tied to being a neutral platform. So these tech companies can choose. If you want the immunity that was intended by the original law back in the day when the internet was a new technology, you can have it, but you have to adhere to neutral norms. If you don't want that, and frankly, in many of the recent court filings, Google and Twitter and these other companies have said, we're a publisher, so when they're sued, for example, for allowing terrorists to communicate on Twitter of their terror attacks, they say, well, we're a publisher, so we have a right to control what's on there. Well, if you're a publisher, you should have the same liability of Fox and CNN and Wall Street Journal and everybody else. You got to choose. You can't have it both ways.
But who makes the decision about what is a neutral place, right? I mean, that's one of the problems now is they say, no, of course we completely fairly enforce these standards. We go after, no, we all know that that's not true. But so who makes that decision that you're neutral?
Well, interestingly, Kim, in recent weeks, these companies are no longer saying that they're neutral. For example, my firm, in conjunction with some other lawyers, filed a lawsuit against Twitter a couple of weeks ago because a radical feminist, who's our client, had the nerve to say men are men and women are women and push back on trans activism. These are facts, people. Whatever you want to believe and be sensitive to trans people, these are facts of science. She said those facts. She was banned permanently. And when questioned about this, the CEO, Jack Dorsey of Twitter, said, well, we can no longer afford as a company and as a society to be neutral on some of these issues. So they're admitting their lack of neutrality, and we should hold them to that standard. I don't think it's that hard Kim, if we amend the law to say you get the immunity if you are neutral, that can be litigated in the courts.
You know, we had a while back